I call this meeting of the Conference Committee on House File 2432, the Judiciary and Public Safety Budget Bill to order. We do have a quorum. Before we get to our agenda, just like to go through a few items. Everyone here today must be seated in the hearing room. There's no standing or sitting in the walkways or aisles. If you need any accommodation, please be sure to check in with our sergeant staff. Signs aren't permitted in the hearing room or at the testifiers table, and clapping other disruptions are not allowed. Thank you to our sergeant's office staff who are present for helping maintain decorum in the committee hearing room. Today's agenda includes adopting additional policy that's been agreed to by the House and Senate and to hear testimony on several provisions that are still being considered. We're going to first start with the testimony, and if we do not finish by 1:30, which I am guessing we probably won't, we will need to recess to the call of the chair. Just so members know, we did drop Senate File 281 from today's agenda as the testifier was unable to join us today. And so as we move through this testimony, the idea is because we have to recess at 1:30 to try to get through as much of the testimony on the bills as possible so that our testifiers aren't having to sit around and wait for us to come back. So we will call on the testifiers for the bills. We'll have member questions for the testifiers, but we'll come back and revisit any discussion on those bills later on. All right, so the first provision we will take testimony on is from Senate File 1665 and House File 1396. These provisions expand the use of drones by law enforcement. A side-by-side of the two proposals has been posted online and printed for the members. There's also an amendment that's been offered by the Senate that's been shared online and printed, and members, you should have the documents in your committee packets. And then before we start with the testimony, I would like House Counsel Jeff Diebel to walk through the differences in the various proposals. Mr. Diebel.
Madam Chair and members, I'll be working off the document. It's entitled, it's H1396-2 on the left side, which is the House language, and it compares it to the Senate position on UAVs. The bill amends 4 different clauses in the UAV statute. It begins with on line 1.10 of the House side. There's a difference there where it provides for preserving evidence, using drones to preserve evidence. And on the House side, it refers to documenting evidence that would be subject to risk, imminent risk, if the use of a drone was not involved. And on the Senate side, it refers to preserve and protect evidence from imminent risk of destruction. Moving to the next change item, you have 1.13 of the House side, the standard for using drones for fleeing suspects. On the House side, it's a probable cause standard, and that is related to probable cause that the person committed a crime against a person or a felony and is fleeing law enforcement. And on the Senate side, excuse me, as brought into conference committee, it was a reasonable suspicion standard that the person might or is fleeing. The amendment that's been offered for consideration by the Senate would maintain the reasonable belief standard for the use of the drone, but it would be a reasonable belief that a crime was committed and that the person is fleeing or might flee police officers. Moving to the next change in both sides is identical, and it relates to the using a drone in a private area with the written consent of the occupant, and that's tied to the public area or current provision, which allows for the use in public area for officer training or public relation purposes. And on the second page of the side-by-side is another provision, new provision on both sides. The House has added a few additional requirements related to the use of drones for missing persons. On the House side, the drone can be used for an active search when the missing person involves a risk of death or bodily harm to the person. And on the Senate side, it simply states that to facilitate the search for a missing person. And Madam Chair, that concludes the overview of the.
Thank you, Mr. Diebel. Next, we'll move on to testimony. If we can have Chief Potts, Sheriff Habel, and Superintendent Evans. We have 3 chairs if you all want to come on up to the table. And we'll begin with Executive Director Potts, please introduce yourself and begin your testimony. Welcome back.
Thanks, Madam Chair and members. My name is Jeff Potts, Executive Director for the Minnesota Chiefs of Police Association, representing the roughly 300 police chiefs across the state, as well as a couple of hundred command staff officers. I'll be brief, Madam Chair. Our association supports, with regard to the three provisions in front of you, I'm referring to the R1. This is a side-by-side that was on the stack outside. The first item that we support is the House version on line .10 to document evidence that is an imminent risk of destruction. We prefer that over the language that says to preserve and protect evidence. Basically, our position is that the drone can't really preserve and protect. However, it can document. Moving on to the second area that we will weigh in on, and that is in regard to the fleeing, language regarding fleeing. We support the A32 amendment. Mr. Diebel just read through that. That is to assist in the lawful pursuit of a suspect who law enforcement reasonably believes has committed a crime and who is fleeing law enforcement or law enforcement reasonably believes might flee. The third provision that the Chiefs Association supports is on the backside of the R2, and that is the Senate language that simply states to facilitate the search for a missing person. Madam Chair, that is the three areas and the positions of the Chiefs Association. Thank you for allowing me to testify here today.
Thank you for your testimony. And Sheriff Habel, if you want to introduce yourself and begin your testimony.
Good afternoon, Madam Chair, members. My name is Scott Habel. I'm the sheriff in Renville County, Minnesota, and I also represent the Minnesota Sheriff's Association today. Regarding these bills, we largely echo what Executive Director Potts just told you. I'll give you some insight as to why on a couple of these. The first one, the Senate side, again, documenting evidence as opposed to preserving and protecting evidence. While they both, I think, accomplish the same thing, if we're talking about the literal task that a drone can do, a drone can document. A drone doesn't necessarily preserve or protect. If it does, it's done so by documenting. So we think that the House side is the preferred language. Moving on to the use of drones for fleeing suspects. Similar to the Chiefs, we would support the newly filed A32 amendment on the Senate side. And then, of course, there, I believe, is consensus over using drones over private areas. And so the last piece then would be using drones in the search for missing people. Our preference is the Senate language in that as well, to facilitate the search for a missing person. And there's a couple of caveats to this. The House side requires that it be an active search for a person that involves risk of death or great bodily harm. There might be some confusion as to when that happens. Many of you have heard my testimony in previous committee meetings. In rural Minnesota, a large part of our geography is covered in agricultural land. And so just as an example, from time to time we get calls about missing children that are in fields. On a bluebird sky day at 70 degrees, if a 2-year-old child goes into a cornfield, are they at risk of death or bodily harm? The answer is no. But at some point they might be, and so our question is, at what point is it that we can launch a drone? If you are the parent of that 2-year-old child who's missing, I can assure you you're going to want, and you deserve, every piece of equipment available to be used to search for your small child, whether or not there's risk of bodily harm or death. So we think the Senate version, simply to facilitate the search for a missing person, is the better of the two options.
All right, thank you. And next up, we have Superintendent Evans. Please introduce yourself and begin.
Thank you, Madam Chair, members of the committee. My name is Drew Evans. I'm the Superintendent at the Minnesota Bureau of Criminal Apprehension. I would just like to highlight as well that the additions the Chiefs Association, the Sheriff's Association have both highlighted that we would be in agreement with. I will note that the specific provision the BCA originally brought forward is in lines 100.17 and 100.18, and these have been combined as it's worked its way through the process. However, the addition is that they have noted I would be in agreement with exactly what they've testified testified here today. You'll note that the A32 amendment would certainly be a reasonable perspective as well, but that the Senate version or the A32 amendment would be the preference of the BCA. The reason being is that this was brought forward as it relates to our work in violent crime, a reduction in our teams, and what we often find is we have individuals that flee for us where we'd be able to utilize a UAV so that we can launch that. If the person flees, and a lot of times we anticipate they may flee based on previous conduct, a number of different factors that we'd be looking at, by utilizing the UAV, we'd be able to set a perimeter and slow down so that our law enforcement officers, as we're working with our partners every day, are not having to chase them, often with guns drawn through backyards. We can set that perimeter, locate them with the UAV, and then call them out in a much more orderly fashion, which keeps the individual that's fleeing safer, and it keeps our law enforcement safer. So either the Senate position or A32 would be the preference of the BCA as this moves forward.
Okay, thanks for your testimony. And then we have Alicia Granzi or Grans from the ACLU. And if the other testifiers could just hang by close so that we can have the opportunity for questions. Welcome. Please introduce yourself and begin your testimony.
Thank you, Chair Moeller. My name is Alicia Granzi, and I'm a staff attorney at the Minnesota ACLU. I'm here today to testify on behalf of the Constitution, which has a warrant requirement that is vital to protecting our rights against unreasonable searches and seizures. When looking at the two proposals before us, the ACLU of Minnesota supports the House side, which requires that someone actually be fleeing from law enforcement rather than a reasonable belief that someone may flee. I appreciate the concerns of the law enforcement that testified here today, but I want to make sure that the people of Minnesota also have an opportunity to have their voices heard. And particularly in light of the fact that in several weeks, it will be the 5th anniversary of the murder of George Floyd, I want to make sure that we are taking into account law enforcement practices that are unreasonable. 2 reports on the Minneapolis Police Department documented the unreasonable conduct of law enforcement across our state, well, in particular in Minneapolis. And I want to make sure that though we say something might be reasonable in this statute, law enforcement don't always act reasonably. The reason the House side mentions probable cause and the warrant requirement, this warrant requirement is very important. This comes from our Constitution. These are the ways that we protect Minnesotans from unreasonable law enforcement search and seizure. We've worked with members of the House to craft this language so that it does really conform to the protections that all Minnesotans have under the Constitution. And I would open up for any questions at this point.
All right, thank you for your testimony. We will open it up for member questions, I guess, and then we'll have member comments. Again, we'll save. We'll bring this back up later to discuss. So let's try to keep it to questions now. Chair Liebling.
Thank you, Madam Chair, and thank you for your comments. You didn't say anything about this last provision, and I also actually wanted to ask the law folks about their view of this too, but on the back side of the page here where we have, they discussed, this is the missing person section, and a difference between the two sides is that the House side says to facilitate the active search for a missing person, in addition to the piece that says, that limits it by, that involves risk of death or bodily harm. And then the Senate side is just to facilitate the search for a missing person, much broader. So I wonder if you had a comment on that piece, on the differences there and whether active is important.
Ms. Granzi.
Thank you, member. Yes, I do have a comment. The reason that the active word is included there is to separate searches for missing persons that may have originated far in the past, 10, 15 years, even a year ago. The reason active is important is that this is something that is potentially an emergency. And again, the warrant requirement is something that we have to as a backstop. So law enforcement goes to a judicial officer and the judicial officer says, yes, it is reasonable for you to use this technology in this way. When there is an emergency, an emergent situation, potentially they don't have time to get a warrant, but that's not the case in investigations that are from far in the past. So it's much easier for a law enforcement agency to get a warrant in order to do that.
Chair Liebling.
Thank you for that. And then, did you also have a comment on having the inclusion of that phrase that involves the risk of death or bodily harm versus not including it? Say we were just to include the term active.
Ms.
Is
Granzi.
that enough?
Thank you, Chair and Chair Liebling. Yes, I do have a comment. The reason that we have those phrases in there, and I would mention that it is bodily harm, which is not a very high standard, it is not great bodily harm, is again to ensure that what law enforcement is doing is actually exigent. It's actually a situation where, you know, we are concerned about the health of citizens. The sheriff mentioned children, and I would argue that if a child is lost in a cornfield, there could be bodily harm happening to that child, even on a beautiful day. Again, bodily harm is not a high bar. It is not that the child will be, you know, will die. It is any harm to the body. So that would be our comment on that.
Thank you, Madam Chair.
And I know I said to save comments, but I had pulled up the definition of bodily harm, just so people know it is defined in statute as physical pain or injury, illness, or any impairment of a physical condition. So it is a very low standard to reach. Okay, other questions for, go ahead, Chair Scott.
Thank you, Madam Chair. And I'm looking at the difference between item number 1 on the side-by-side on lines 1.8 and 1.9 and trying to compare that to the missing person piece on the back side. And for the record, item 1 says during or in the aftermath of an emergency situation that involves the risk of death or bodily harm to a person. And maybe law enforcement can help me out here, but wouldn't that include a missing person?
So we want to, I don't know who wants to answer this. Do we want maybe the chiefs or sheriffs to come back up to the testifier table? If there's a gap in the current law that doesn't cover missing persons. And the superintendent, they're all coming. But Ms. Granzi, stay close by too as well.
Okay, would you
Thank
like
you.
me to?
Just, you're fine. All right, go ahead, Sheriff.
If I understand the question correctly, Madam Chair, the question is, does lines 1.8 and 1.9, is that sufficient to cover the new language? Is that correct?
Chair Scott.
Yeah, thank you, Madam Chair. Yes, it seems like the language that says during or in the aftermath of an emergency situation. So if someone is missing, in my mind, that's an emergency situation. So why would we need the language on the backside if we have kind of this sort of exigent circumstance, broader language in 1.8 and 1.9?
Sheriff.
Thank you, Madam Chair. I think this, again, goes to just interpretation of the literal meanings of these terms. An emergency to one person is much different than an emergency to another person. I think the idea is just to clarify exactly when we can and cannot use UAVs. And again, these are exceptions to a search warrant requirement. And in some of these cases, I'm not sure that a search warrant is even appropriate. Perhaps a court order, but a search warrant would be difficult in these situations because there is no crime that's committed. It's not evidence of a crime. I'm not sure what the mechanics of that might look like.
Chair Scott.
Thank you, Madam Chair. That just, I happened to see that and I'm thinking, but I think what we passed into law several years ago already kind of allowed for this sort of thing, but I understand the belt and suspenders approach, I guess, so.
You know, Chief Potts, did you have more to add for that question?
You know, I think that, Madam Chair and members, thanks. I think the sheriff did a fine job. I would just add to get to this point about it's sometimes a question as to whether or not it's an emergency, and adding a clause in missing persons, I think we think is appropriate. We think about a small child in a farm field, or as was talked about, but this happens almost a daily basis where some elderly person with dementia has gone out for a walk and simply hasn't returned. And that's also a missing person case, may not be considered an emergency situation to some, but to that person's family member, I would argue that it is. I think this just clarifies when you're searching for a missing person. And drones can be extremely valuable in those situations in terms of quickly, especially if the weather is obviously a factor. So I think it's just for clarity.
Chair Latz.
Thank you. On this missing person thing, I'm just trying to figure out why you wouldn't use a drone in any situation. I mean, if the standard is a little bit of pain is bodily harm, which is the standard definition, then that's basically no standard at all, because anyone who trips while they're out missing, where they wouldn't trip if they were back home, might be exposed to a risk of bodily harm, number one. Number two, if someone is missing, especially if they're a young child or if they're vulnerable in some way, even if they aren't exposed to bodily harm risk, the mental anguish that they might be experiencing relating to not being where they're supposed to be, being lost or whatever, seems to me is worth it. And third, if you've got people to be out looking, spending resources, collecting friends, family, relatives, law enforcement, anyone else, go out and try to find this person who's missing, why wouldn't we just use a drone to find them? I don't see what the harm is on that, if it would expedite the discovery and recovery of a person that's out there. And the final thing is, how the heck do you prove that you're in compliance with this statute? If someone asks a question later on and says, well, were they at risk? Well, we don't know if they were at risk. We're not wherever they are. I mean, they might be standing under a tree during a sunny day and they're fine, but they're still lost and their family is still worried to death about them. They don't know where they are. As far the family might think they're standing next to a pond about to fall in and they don't know how to swim, no matter what age they are. I mean, there'd be no way to prove that you've complied or not complied. It'd be a complete fabrication of ideas to try to comply with this. So I think we're better off just saying, use whatever tools, human or technological, to find someone who's missing. So for me, I guess I don't have a question. I'm just trying to figure this out. And I did have a question, maybe it's a comment, I'm not even sure, on the middle portion also. Fleeing or think they're going to flee. And maybe this is a question for Ms. Gramsci from the ACLU. How do you distinguish between using physical human resources in a squad car or officers in uniform surrounding a person they think they might flee, from having a hovering camera also surrounding a person who might flee to prevent that flight? I guess I don't understand the ACLU's distinction there, so maybe you can help me understand that.
Ms. Granzi.
Thank you, Chair. Thank you, Senator Latz. Presumably, even with the drone being in the air, the law enforcement agency is still going to have boots on the ground. What we're worried about is at a traffic stop, for example. Someone is stopped at a traffic stop and the law enforcement agent potentially thinks, I've pulled this person over before, they may have fled, but I've also pulled them over and they haven't fled. But it's potentially reasonable for me to believe that they're going to flee, so I'm going to put a drone up and I'm going to just intimidate them with that drone, which again, they are being pulled over, but it's another question of, we have these resources, but do we need to use them all the time? Having a more tailored and narrow exception to this is very important because, again, while it is important to, as law enforcement talk about, to fight crime, the Supreme Court has talked about how, in our zeal to address the problems, we can't give police unsupervised powers to invade our privacy. And again, I appreciate the idea of curbing the use of police resources and being smart about it. I think without these cabins, without these guardrails, we're at risk of essentially eating the warrant requirement. So the exceptions are so broad that we don't have a warrant requirement at all. And again, if a police officer, and potentially I'm thinking about officers who are executing what they are saying are high-risk warrants, there's already a warrant in place. They can simply ask for additional resources from the government or from the judicial system for permission to use a drone. It is not that difficult to get a search warrant. I wish it were more difficult, but at the end of the day, it is a relatively quick process from what I have gathered in my experience as a criminal defense attorney. And it is possible to get a warrant in a relatively quick enough time frame that you would want to go and to execute these high-risk search warrants or these high-risk arrests.
Chair Latz.
Yeah, thank you. Just a follow-up. If you're talking about, you've done an investigation, you think someone's got drugs in their apartment, and you're going to do a search warrant, you think they might flee, yeah, you got plenty of time to get a warrant. If you're at a traffic stop and it's a lawful stop, you've already got articulable suspicion under the Constitution to stop them. Assumption, but that's the constitutional threshold. In the time it takes to get a warrant to put up a drone, they're long gone. You can't do that. I mean, it takes it takes a second for someone to step on the gas. It takes at least 15 minutes to half an hour to get a warrant, especially if you're sitting in a squad car, submitting it on your mobile data terminal, and gets sent off to wherever a judge is who steps out of a hearing to look at the warrant and review it. I mean, it just doesn't happen that quickly. You see it all the time when there are warrants for blood or urine tests on DWI arrests. I mean, it takes a little bit of time. So it seems to me if you've already met the constitutional threshold for a stop, which is where you are at in this stuff here, you've already got a lawful pursuit of a suspect. Then whether you use a human body or technology, if you got one officer and you can't rally 10 other squad cars to that location quickly enough, but you've got a drone you can put up and maybe save a few lives in the process, so you don't have someone makes a stupid decision to flee when they know there's a drone's going to follow them. Maybe you save some family from being T-boned in an intersection. Or you save the life of a passenger in that vehicle when they hit a tree. I make a living holding government accountable as well for stepping across constitutional boundaries, but I just don't see how this would intrude on the constitutional boundaries. I don't see a warrant as an alternative for these situations. But thank you.
All right, we have two members that have raised their hands, and then we have to, I'm sorry, we're going to have to recess. Chair Novotny?
Quickly, Chair Moeller, to answer Senator Latz's question, is probably the only person at the table that I can tell has ever detasseled corn. If you're out in any cornfield in July, you're at risk of bodily harm. I have two questions.
The bugs are really big.
Well, death by 1,000 cuts. My question would be, but first for the sheriff, we have under the House provision line 1.8, during or the aftermath of emergency situation involves risk of death, bodily harm. And that'll tie to my next question, but would you consider a person that's suicidal and is wandered off into a field or a wooded area to be that emergency situation that would be covered under risk of bodily harm?
Sheriff Habel?
Thank you, Madam Chair. Again, the answer is it depends. For me personally, absolutely. But again, the definition of emergency would certainly change from person to person. This clarification in this change in statute would make it clear for anyone. If that is an emergency, it is what it is. You don't have to define it as an emergency. Nobody would be able to come back later and say, that was not an emergency, you shouldn't have done that, you stepped over the constitutional line. Instead, we fall into parent 12 on the Senate side, facilitate the search for a missing person.
Chair Novotny?
Thank you, Chair Mueller. And the next question will be for Superintendent Evans. Superintendent Evans, just for clarification and to get it on the record, missing person, would a person, going back to the question I had before about someone that's suicidal, someone's suicidal and believed to be armed, for example, would they meet the definition from what you're reading as missing person? Would they have to be actively involved or entered into the state computers as missing, or an attempt to locate for suicidal or a COPS grant? Would they count as being missing under these statutes?
Superintendent.
Madam Chair and Chair Novotny, yes, I don't think they'd have to be necessarily entered as, missing, but it'd be reported in some way if we didn't know their location. One thing that I would, as I answer the question, that I do think is important, because I think it's come up in some of the questions along the way. Many of these uses we're debating are constitutional. The challenge is we have a statute that's narrower than the Constitution, and so that's why we're working through some of these. If this statute didn't exist, many of what we're asking for here today to be added back into this are constitutionally permissible under our statutes right now. With a traditional aircraft, for example, all of these have been done for many, many years under the Constitution, and we'd have to justify that in the process. But that's where I think some of this nuance that we lose as the process is we're trying to add back in what would traditionally be exceptions to the warrant requirement already. And so that's what we're trying to narrowly tailor them with these exceptions we're asking for.
Chair Novotny.
Thank you, Chair Morley. That'll work.
All right, Senator Umuver-Baton.
Thank you, Madam Chair. Just a question for Ms. Grancy. I know that you talked about concerns with using reasonably believes in the amendment and law enforcement reasonably believes might flee. Can you talk about the House language asks for probable cause to believe has committed either a crime against persons or a felony, whereas this amendment just says committed a crime, and your take on that?
Ms. Grancy.
Thank you, Chair. Thank you, Senator Umuver-Baton. If I understand your question, it's to compare the amendment, let me just pull it up here. The House language with to assist in the lawful pursuit of a suspect who law enforcement reasonably believes has committed a crime. Again, the reason we are tying this to probable cause to believe that someone has committed a crime is, again, that is language in the Constitution. And we don't want people, law enforcement, chasing people who are moving away from them simply because an officer and generally the standard is reasonable articulable suspicion of committing a crime. Officers have talked about how someone walking away from them is potentially going to give them reasonable suspicion that the person has committed a crime, and the Constitution does not allow that. So what we're doing is trying to tie the language closely to the constitutional requirements to when law enforcement can be acting to enforce a criminal law. So probable cause to believe that someone has committed a crime against a person or a felony. Again, spending law enforcement resources to pursue someone they have reasonable suspicion has committed a misdemeanor. Generally, we want to think about, is that something that a law enforcement officer really needs to be doing? When we're chasing people, because that is what this is, it's a pursuit, it's a chase, which intimidates people. We want to make sure that we're doing it for the right reasons. And again, and if I may, I want to clarify the House section allows for when someone is fleeing. So if someone is fleeing, the drone could be used without a warrant. It's not, but if law enforcement simply reasonably believe that someone will flee, that's essentially removing a lot of the constitutional protections that we do have. We want to have higher standards for when police are engaging in, again, chasing and pursuing people. I hope that answers your question.
Senator Umuver-Baton.
Thank you, Madam Chair. Yes, that was helpful. And you talked about misdemeanors, but I'm just curious if you have any specific situations that you're concerned about if there wasn't a probable cause standard that's also tied to crimes against persons or a felony.
Ms. Grancy.
Thank you, Chair. Thank you, Senator Umuver-Baton. What we're worried about is over-enforcement of what we call livability crimes. frequently something like trespass or public urination, or minor theft. You know, those are misdemeanors. And under the Senate side language and the amendment proposed, those would be things that we would use a drone for, or to chase and pursue someone. And so we're concerned that law enforcement are going to be using these tools in ways that are not cabined, and in ways that aren't really appropriate. We don't want to use all of the tools we have for everything. We want to make sure that we're doing smart policing and constitutional policing.
Any follow-up, Senator?
Good.
All right, I don't see any other questions from, oh, go ahead, Chair Scott.
Well, Madam Chair, I can hold that if we're going to resume this topic when we come back, or if we're not, I just had one last question.
Go, please ask your, because we will release the testifiers, so if you have questions
Okay.
for the testifiers, please go
Okay,
ahead.
very fine. I do think, on the last page there at the top, to facilitate the search for a missing person, I do think there has to be some narrowness to that. It can't be that broad, because you may have an open case for a missing person that's a year old. And after so many months or so much time has passed, in my mind, law enforcement would need to go, get a warrant if they, for some reason, wanted to start searching again. You can't leave that case open forever because it's no longer exigent circumstances. It's no longer emergency. That was my only point.
Do you want?
No,
Yeah.
no question, I guess,
Okay.
really, but just that point.
All right, so not seeing any other questions
Yes, add action.
from our members. So thank you to our testifiers. We will release you. Sorry to the other testifiers that we did not get to your testimony. And I will move a recess to the call of the chair. Staff will send out an email to members and the listserv when we plan to reconvene today. And with that, we are in recess.